City of Grants Pass v. Johnson. Homeless people in the city of Grants Pass are being ticketed for sleeping on streets and park benches. The case is brought to district court and argues that the ticketing of homeless people for sleeping in public violates the cruel and unusual punishment clause of the Eighth Amendment. The case is then brought to the Supreme Court to determine if cities can fine and arrest people for sleeping outside in public when adequate shelter is unavailable. How did we get here?
The Bill of Rights has just been ratified. Let's take a closer look at the Eighth Amendment. Excessive bails shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted.
The Eighth Amendment was borrowed pretty directly from the English Bill of Rights of 1689. In the English Bill of Rights, the provision says, excessive bail ought not to be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Sound familiar?
Now that we know where the amendment came from, what does this actually mean? In simpler terms, this amendment was made to ensure that punishments fit the crime and to prevent government overreach in the legal system. At this time in history, this amendment was quite vague. There were no parameters for what constitutes cruel or unusual punishment, as well as who criminal punishments could be used against.
So let's take a look at how this amendment has changed over the years. The Eighth Amendment has changed over time by specifying what constitutes cruel and unusual punishment. Something that has remained the same throughout U.S. history is the use of the death penalty, except for a slight blip in 1972, where the court ruled in Furman v. Georgia with a 5-4 decision that the death penalty was cruel and unusual punishment, putting all executions on hold. This decision was quickly overturned only 4 years later in Gregg v. Georgia with a whopping 7-2 decision. I guess they really missed the death penalty. Despite the death penalty being enthusiastically reinstated, who and what can be subject to the death penalty has changed over the years, becoming more specific in what crimes justify the death penalty and which people it can be used for. Let's take a look at some court cases.
In 1974, Ehrlich Anthony Coker escaped from prison in Georgia, where he was previously being held for rape, kidnapping, first-degree murder, and aggravated assault. He broke into the home of Alan and Elnita Carver, raped Elnita, and stole the family car. He was sentenced to death on the basis that he had prior capital felony convictions and committed the rape in the course of an armed robbery, another capital felony. In a 7-2 vote, the Supreme Court ruled that the death penalty was, quote, grossly disproportionate for the crime of rape and violated the Eighth Amendment. This is our first instance of limits being put on what crimes constitute the death penalty, helping to more clearly define cruel and unusual punishment.
Now, let's take a look at a case that puts a limit on who can be subject to the death penalty. In 1987, 15-year-old William Wayne Thompson brutally murdered and mutilated his brother-in-law. He was tried as an adult and convicted of first-degree murder. He was sentenced to death. In a 5-3 decision for Thompson, the court ruled that the death penalty for anyone under the age of 16 was cruel and unusual punishment, making it unconstitutional. This case helped to further outline the specifics of the death penalty, which continued to clarify what constitutes cruel and unusual punishment.
In 1996, Darrell Renard Atkins was convicted of abduction, armed robbery, and capital murder. During the trial, a forensic psychologist testified that Atkins was mildly mentally disabled. Atkins was convicted and sentenced to death anyway. In a 6-3 opinion, the Supreme Court ruled that the death penalty for mentally disabled people was cruel and unusual punishment, violating the Eighth Amendment. They also cited the evolving standards of decency as part of the reason they saw execution as an unsuitable punishment for mentally disabled people. This case continued to narrow the scope of people who could be executed and further defined what counted as cruel and unusual punishment.
In 1993, 17-year-old Christopher Simmons brutally mutilated and murdered his neighbor. He was sentenced to death due to the decision in Thompson v. Oklahoma, which allowed the death penalty for anyone over 16. After the ruling in Atkins v. Virginia in 2002, the Supreme Court decided to reconsider Simmons' case. In a 5-4 decision, the Supreme Court ruled that the evolving standards of decency had made it so the death penalty for crimes committed by minors, anyone under 18, was against the Eighth Amendment clause of cruel and unusual punishment. This case added to the decision in Thompson v. Oklahoma and further developed the way we define cruel and unusual punishment today.
Now that we have gone over some cases that show how the use of the death penalty has gotten more specific, let's see if we can better define the Eighth Amendment today. The Eighth Amendment protects you from cruel and unusual punishment, which needs to be a conscious decision and is specified as the death penalty only for murder, not for people under 18 or the mentally disabled, no taking away citizenship, and no fines for homelessness. Now let's look at some court cases that help to define the Eighth Amendment today.
In 1944, U.S. Army Private Albert Tropp escaped from the military stockade where he was being held in Casablanca, Morocco. He surrendered, was convicted of desertion, and sentenced to hard labor, loss of all pay, and dishonorable discharge. In 1952, he applied for a passport but was denied because he lost his citizenship as part of his sentence. In a 5-4 decision, the Supreme Court ruled that the loss of citizenship for wartime desertion was unconstitutional. It violated the cruel and unusual punishment clause of the Eighth Amendment. The court also ruled that expatriation could not be the punishment for any crime other than treason. This court case added the specification against removing citizenship into the definition of cruel and unusual punishment.
In 1991, Pearlie Wilson was being detained in a correctional facility in Ohio. He claimed that he experienced cruel and unusual punishment by the prison officials, and that they showed deliberate indifference towards his conditions. The U.S. Court of Appeals in his circuit ruled against him, and decided that he had to prove that the officials had a culpable state of mind. The Supreme Court agreed with this decision, ruling that to constitute cruel and unusual punishment, the officials had to exhibit intentional cruelty and have a culpable state of mind. This case further specified what cruel and unusual punishment was by deciding that it must be a conscious decision for cruelty.
Now we have returned back to where we started. In 2018, the city of Grants Pass in Oregon began ticketing homeless people for sleeping on streets or park benches. The number of homeless people in Grants Pass exceeded the number of beds available in local homeless shelters. The case was brought to district court where it was ruled that based on the unavailability of shelter beds, the city's enforcement of its anti-camping and anti-sleeping ordinances violated the cruel and unusual punishment clause. The case was heard by the Supreme Court on April 22nd of 2024, but the Supreme Court will not decide on the case until June 30th, 2024.
We are currently experiencing what may be a new way to specify the definition of cruel and unusual punishment. The conclusion of this case will determine if ticketing homeless people for sleeping outside violates the Eighth Amendment, and a new page in the history of the Eighth Amendment will be written.
In contemporary society, the main benefits of the cruel and unusual punishment clause of the Eighth Amendment are the more specific outlines of what constitutes cruel and unusual. This means I couldn't be executed for something like robbing a bank, but a murderer over the age of 18 could be executed.
The Eighth Amendment was made to protect us from unjust punishments. But how do you make sure that people are being punished enough, but not too much? This is the question that underlies the debate over the Eighth Amendment.
The main argument over the Eighth Amendment today is whether or not the death penalty should be legal. The people who are against the death penalty believe that it doesn't do any good for society, ends up killing wrongfully convicted people, and belongs in a past era. Those who are in favor of the death penalty think that those who committed the worst crimes deserve it, and that the threat of execution deters people from committing crimes.
The challenges that came along with these arguments stem from the incredibly vague language used in the original amendment. Different people interpret cruel and unusual punishment as different things, even within the Supreme Court itself.
James Ingram and his friends were being disruptive and late for class at Charles R. Drew Middle School. They were hit and paddled by Principal Wright, to the extent that James later ended up in the hospital for his injuries. The students filed a class action lawsuit arguing that they were deprived of their Eighth Amendment rights. In a controversial 5-4 decision, the Supreme Court decided that corporal punishment in schools did not constitute cruel and unusual punishment because the Eighth Amendment only applied to criminal punishment. The dissenting opinion argued that if corporal punishment violated the Eighth Amendment against criminals, similar punishments cannot be used against students for lesser infractions. Seen in this case, even within the Supreme Court, there were disagreements over what constitutes cruel and unusual punishment.
I can see why it's so controversial. I mean, what does cruel and unusual even mean? Is the death penalty cruel and unusual? As society progresses and changes, does this vague description change as well? And who knows what the authors of the Constitution really meant when they prohibited cruel and unusual punishment?